Hello everyone. This week you're going to deal with liberty, the right to liberty, and I selected a particular focus on pretrial detention since we already discussed that with regard to overcrowding of prisons. And you know that we are talking in these cases about detention when there is no judgment in a criminal case yet, but there is reasonable suspicion about the crime, and the defendant is detained for that and for many other reasons. On the one hand, we have the presumption of innocence. On the other hand, we have the public interest of preventing the potential fleeing, absconding of the defendant, and so on. We were going to do this soon. Now, I thought that by this video, I just provide you a couple of explanatory remarks so that you clearly understand what I meant by the slides, by the information that I put on the slides. And please, when you are preparing for the exam on the right to liberty, feel free just focus on this one aspect, pretrial detention. But of course, if you feel like widening your knowledge, then feel free to read or prepare also based on the background reading. So, focusing on the slides. If you go on slide number 2, I put the two links, a link that brings you to the website of the Fair Trials. The Fair Trials is an international kind of NGO with offices in Brussels, London, and Washington, D.C. And so on that link, you find a video which I thought is very useful to bring you into the perspective of this whole problem. It's a very short video, so it's useful to watch it if you wish to look at the practical significance of this whole topic and why it's a very important human rights concern. So if you look at the slides, then you see that basically there are two major issues raised on the slides. And one is when the pretrial detention is ordered, when it's decided upon for the first time. And then the other aspect is the prolongation of pretrial detention, because it can be upheld even for many years. Without a judgment delivered in the criminal case. So in the very beginning of the criminal proceeding, it's still possible to base the decision about pretrial detention solely on reasonable suspicion of a crime. Now you see a very easily understandable notion about it on slide number 4. Based on the case law of the European Court of Human Rights. And there on this slide, I emphasize that it's not enough to have just reasonable suspicion and immediately you can be, as an accused, someone suspected of a crime, can be detained and arrested. It's not enough. Even at this very first point of the criminal procedure, it must be assessed by the authorities whether it's really necessary to put the accused, the suspected person in prison, in detention. And this necessity standard was very important in this Polish case that I put on this slide, Bruskiewicz versus Poland, where the crime was, so the procedure was about false accusation. It's a very minor, very not a severe crime, and so in the hearing, the defendant was leaving the courtroom without permission, and that was the sole reason why the court decided to put the defendant in detention, which lasted for more than 2 months. So in that case, the European Court found that even if there was a well-based, reasonable suspicion, a very strong reasonable suspicion, it was not enough. Still, considering the fact that it was not a severe, not a grave crime, and considering the fact that it was just one occasion when the defendant left the courtroom without permission, it was not enough to say that detention of the defendant was necessary, and so the court found a violation of the European Convention. Now, even at this very first stage of the criminal proceeding, national authorities should and criminal authorities should weigh the probability and the justifications behind alternative coercive measures as to pretrial detention. So even in this case, this basic principle of graduality, that the least restrictive measures should be found, these principles are to be applied. So the authorities should consider whether it's enough to decide on bail or house arrest or geographical ban, as you see these alternative measures listed on slide number 5. And so here, when deciding about alternative measures, the health condition of the defendant is very important, as I pointed out on the slide, and I put there another Polish case, Jablonski versus Poland, where the government of Poland wanted to, or tried to argue at the European Court that they decided to keep up the pretrial detention instead of deciding about alternative measures, because the health condition, the deteriorating health condition, was due to the action of the defendant himself, because he was the one who put himself on hunger strike, and that strike addressed all the problems with regard to procedural rights. And so basically, the government said that the defendant himself was responsible for the length of procedure. It's not an acceptable justification, not acceptable for by the European Court of Human Rights. Even in this case, if there is the defendant is in a very bad deteriorating health condition, then house arrest should be preferred to pretrial detention, which probably contributes to further deterioration of the health condition of the accused or defendant. Now, if we go on to the prolongation of pretrial detention, and if you look at slide number 7, then you see this basic thesis and standards set by the court, which is that reasonable suspicion is not enough after a while. So it's a precondition, a necessary precondition of the lawfulness of continued detention. But after a certain lapse of time, it no longer suffices on itself. So that's why if pretrial detention is upheld for many months and years, then further grounds for the prolongation of pretrial detention should be there in order to have pretrial detention which is in compliance with the European Convention. So those grounds you see on slide number 8. And risk of absconding, obstructing the investigation, committing further crimes, public safety can be another ground, or the security of the detainee. Now, I want you to look at the ground of the risk of absconding and the risk of obstructing the investigation for a second with me right now. On slide number 9, I'm dealing with risk of absconding. And so there you see 2 cases where the Letelier versus France and the AB versus Hungary. Through these cases, I wanted to emphasize that in this and deciding about whether there is a risk of absconding, not only the gravity of crime is significant, but also the particular attitude of the defendant himself or herself. So whether he or she cooperates with the criminal justice stakeholders, he or she participates in the public hearings. So there's no need assume that he or she would flee criminal justice. Of course, there are other relevant circumstances that you find on the slide, but just focusing on the attitude of the defendant. For example, in the case of the Letelier versus France, you see that this wife who was accused of murder of her husband, so it was a very grave crime, but based on a judicial decision, she was released after 6 months, and she didn't escape. She just repeatedly contributed, like appeared at the court, and she didn't flee anywhere. Still, the prosecution services appealed this decision about release, and so on appeal, she was rearrested. So the appeal judicial body, which is not equal to the first instance judicial body who took the decision about release. So they overruled this first decision about release, and she was put back in detention. And that was followed by 2.5 years of pretrial detention, based on this justification by the French government that there was a risk of absconding. And so the European court rejected this argument of the government, saying that, sorry, but the woman just stayed there in her own place of residence and didn't want to flee at all. So you just can't base the whole pretrial detention prolongation on the risk of absconding. In the other case, you see that the defendant, the Hungarian defendant himself, voluntarily went to the police after he got aware of the fact that he's searched for. And so this kind of attitude, when even without arrest, the defendant and the suspected person gives himself or herself up at the authorities, is a very strong indicator in the eyes of the European court that that the defendant didn't want to flee criminal justice. Now, of course, in this case, it was also relevant that while the investigation was ongoing, the authorities referred to the risk of obstructing criminal justice, that the defendant would threaten potential witnesses or would destroy documentary evidences and so on. Now, this kind of argument, which is the second ground, obstructing criminal justice, this can be referred to only in the investigatory phase. Or at least in a convincing manner. Why? Because after the investigation is closed, then all the evidences are gathered, basically. After that, there is still a probability, there is still a possibility that witnesses can be threatened before a public hearing at the court. But still, the investigatory authorities are in the possession of very strong evidences. So it's highly unlikely that the European Court would accept such a reasoning just solely based on the risk of obstructing criminal justice when the investigation is done, is terminated. All the evidences are gathered by the authorities. So that's why in this case as well, it was relevant that the risk of absconding was to refer to only after the investigation was closed. So the obstruction of criminal justice couldn't be successfully referred to anymore. So then came in the picture the risk of absconding. So it was crystal clear for the European Court that it's kind of made up argument, especially considering the fact that the defendant himself gave him up at the authorities earlier. Okay, and then the last explanatory remark related to the risk of obstructing the investigation. The second ground, potential ground, and that I touch upon in slide number 10. Here, I just want to draw your attention to the fact that if it's not only the attitude of the defendant, which is very significant, but also when it comes to the assessment of the prolongation of pretrial detention, but also the attitude of the authorities is extremely important. So when we have an investigation and the pretrial detention for years, prolonged for years, and we have, let's say, 1 year when the investigative authorities did nothing, there is no hearing of a witness, there is no interrogation of the defendant, there is no gathering of documentary evidences, then it's very clear that the authorities are doing nothing. And they are violating the right to liberty and the presumption of innocence without any strong reason, keeping the defendant in pretrial detention. And so because of that, this factor, how the authorities worked and whether they took any investigatory measures, this is very important. And so I put here on this slide number 10, this Swiss case, W versus Switzerland, which demonstrates that if we have a very complicated case, so in this case it was economic crimes, fraud, many defendants involved, and many injured parties involved, and hundreds of bank accounts to be reviewed, and many witnesses to be heard, and thousands of pages of documentary evidences, then obviously even an extreme length of pretrial detention, like in this case it was more than 3 years, is acceptable for the European Court of Human Rights. Like in this case, there was no violation found by the court with regard to the length of pretrial detention, because the authorities need much more time for a thorough investigation of the case. All right, I stop here now, and I hope that these explanatory remarks help you understand the slides. If you happen to have any questions, then don't hesitate to ask me on the Moodle. Have a nice day.